The United States government is launching the largest ever push to revoke citizenship from naturalized Americans.
Yeah, they're taking something like 17 individuals to federal court in a single month.
Right, which is unprecedented, but it begs the question, is this a necessary defense of the nation's highest privilege, or the creation of a precarious second-tier status for millions of Americans? Welcome to the debate. Please take a second to like, subscribe, and follow the show.
Absolutely.
Real quick, before we dive in, an update on the Martin Stevens versus OpenAI situation, just to clarify the facts out there.
Yeah, there's been a lot of misinformation on this.
Exactly. So this is not a lawsuit. There is a voluntary quiet period. No settlement has been confirmed. The dead man's switch was not activated. And most importantly, Stevens is perfectly safe.
Good to hear. All right, so returning to our main focus. Back in June 2025, a Department of Justice memo elevated civil denaturalization to a top enforcement priority.
Right.
And fast forward to the spring of 2026, and the DOJ has announced dozens of cases targeting individuals who allegedly concealed serious offenses or committed fraud during their naturalization process.
Which raises a really fundamental question for us today. Is the aggressive expansion of civil denaturalization a rigorous and necessary mechanism to protect the legal integrity of U.S. citizenship?
Or does relying on civil procedures to, bypass criminal constitutional protections effectively undermine the permanence of naturalization itself?
Right. So I'll be arguing that civil denaturalization is a highly scrutinized, court-mandated process that is absolutely essential for rectifying unlawfully procured citizenship. I mean, U.S. citizenship is a privilege, right? It has strict, congressionally imposed prerequisites.
Sure, but...
And civil denaturalization is used exclusively to correct illegal procurement or willful misrepresentation, meaning the individual was never actually eligible for citizenship in the first place. The burden of proof falls entirely on the government to provide clear and convincing evidence.
Right, but the context matters.
Well, this tool is vital to strip status from individuals who concealed horrific pasts. Terrorists or war criminals like Arnoldo Vasquez, so they can face proper immigration consequences.
And I will contend that utilizing the civil route creates this unchecked dragnet that strips millions of naturalized citizens of fundamental due process rights. The issue here isn't about protecting the country from war criminals. It's not. No, it's the weaponization of the civil mechanism to bypass the legal protections of the criminal system. If the government pursues criminal denaturalization, you get a 10-year statute of limitations, right? You get the right to a jury and a government-appointed attorney.
Right.
Civil denaturalization has none of those safeguards. By shifting enforcement to the civil arena, the DOJ is treating 24.5 million naturalized citizens as, second-class Americans who live under the perpetual threat of a federal lawsuit they just simply cannot afford to fight.
Wait, let me stop you there, because I think a listener might be a little confused by that distinction.
Okay, are you saying that if someone lied on their naturalization paperwork decades ago, the government can just drag them into court today and they don't even get a lawyer to defend their citizenship? Walk me through how that actually happens.
Exactly. That is exactly what I'm saying. Because civil court is technically about resolving disputes in legal status.
Not criminal charges.
Right. Not putting you in a prison cell. So the Constitution doesn't guarantee you a public defender. And the DOJ is actively exploiting this mechanism.
Wow.
Yeah. By shifting these cases away from criminal court and into civil court, they eliminate your right to a free lawyer. So what happens when the DOJ files a massive federal lawsuit against a working-class citizen 20 or 30 years after their oath ceremony?
They have to pay for it themselves?
They are entirely on their own. The government can effectively bankrupt the citizen. Even if the government's case is weak, the citizen might default simply because they can afford, $100,000 legal fees to fight it.
I mean, I see why you think that, but let me give you a different perspective here. Let's think about this conceptually. It's analogous to discovering a doctor has been practicing with a forged medical license.
Okay.
We do not grant them a statute of limitations on that deception just because they haven't been caught for 20 years, right? We strip the license. And the guardrails protecting citizens here are actually incredibly strong.
I have to disagree with incredibly strong.
Well, look at the Supreme Court. Their ruling in a case called Maslanjak dictates that a false statement only warrants denaturalization if it is, quote, material.
But what does material actually mean in practice, though?
It means there has to be a direct, causal link to the original citizenship approval. A naturalized citizen is not going to lose their status over an innocent mistake or a forgotten prior address or a typo on their application form.
Right, but
The government has to prove that the lie actually mattered to the decision, and they have to prove it with evidence that leaves essentially no doubt.
that sounds incredibly reassuring on paper, sure. But in reality, it's a procedural nightmare. You are assuming the target is always a clear-cut forgery or a war criminal.
Well, those are the primary targets.
Not anymore. The June 2025 DOJ memo explicitly expanded denaturalization targets far beyond that. They added gang affiliation, human trafficking, and, crucially, financial fraud.
Right?
And the mechanism they are using to do this is deeply concerning.
You're talking about the recent strategy of using guilty pleas from criminal cases, right? Like the Volgaev and Cabrera-Diaz cases in 2026?
Exactly. I'm sorry, but I just don't buy that this is standard protocol. Let me tell you why. Prosecutors are systematically using criminal plea deals to establish factual records that guarantee an automatic civil denaturalization later.
Okay.
It's like playing a high-stakes poker game where one player gets to look at the opponent's cards, but only if they agree to call it go fish instead of poker.
That's quite the analogy.
Well, by calling it a civil case instead of a criminal one, the government suddenly gets to play by much easier rules. When a defendant stands before a judge and confesses to a crime to get a plea deal, what lawyers call an allocution, they aren't told that this very confession will be handed over to civil prosecutors to strip their citizenship later.
Right.
You cannot claim this is just about protecting the system when it's being used as a secondary, hidden punishment tacked onto unrelated criminal sentences.
I really have to push back on the idea that it's a hidden punishment. It is a statutory consequence of failing to meet the basic requirements of naturalization. Let's look at the actual logic behind those plea deals.
Sure.
To naturalize, you must prove you have good moral character for a continuous period, usually 5 years right before you take your oath.
Right, the statutory waiting period.
Yes. So, if an individual pleads guilty to running a multi-million-dollar Medicare fraud ring, and the facts show they were running that ring during those 5 years, it proves they lacked the required good moral character at the exact moment they applied for citizenship.
I get that, but
They were ineligible. The DOJ isn't creating some hidden trap. They are merely enforcing the law efficiently. They're using facts the person already admitted to, rather than, holding a redundant, expensive mini-trial to reprove the exact same fraud.
But that efficiency comes at a massive constitutional cost. And this brings us to a really profound issue, rooted in a landmark Supreme Court case, Afram versus Arrest.
Okay, let's talk about Afram.
The core principle of that case is that Congress cannot just strip away someone's citizenship. A citizen has a constitutional right to remain a citizen unless they voluntarily relinquish it. This rapid expansion of civil denaturalization blurs the lines between birthright citizenship and naturalization, effectively creating a two-tiered system.
How so, though?
Think about the mechanics of it. A U.S.-born citizen can commit that exact same Medicare fraud we just talked about. They will go to prison, absolutely, but they will never lose their citizenship.
Well, yeah.
But if a naturalized citizen commits it, under this expanded civil dragnet, they are stripped of their citizenship, they lose their passport, they revert to a green card holder, they face deportation. And worse, it can nullify the derivative citizenship of their children.
The derivative citizenship, right.
Yeah, meaning kids who gain citizenship through their parents can suddenly lose it too. How does that honor the idea of equal justice under the law? Citizenship shouldn't come with an asterisk.
See, that framing fundamentally misunderstands the legal distinction at play here. I agree that birthright and naturalized citizens are equal. But you have to look at the timeline. Citizenship is never revoked for crimes committed after naturalization.
Right, but
If a naturalized citizen commits Medicare fraud 10 years after taking the oath, they go to prison just like a birthright citizen. They do not lose their citizenship.
But if the crime overlaps with their application,
Exactly. Denaturalization solely occurs if the underlying crime proves the naturalization itself was a fraud from the start. It is not punishing present behavior. It is correcting a past administrative failure. If you obtained the highest privilege of this nation by lying about your criminal conduct, you never actually held that privilege legitimately.
look, I understand the logic of correcting an administrative failure. We certainly agree that extreme cases, identity fraud, hidden atrocities, war crimes, those inherently invalidate a grant of citizenship.
Right.
No one is arguing that someone who lied about participating in war crimes should keep their U.S. passport. Where we remain divided is the mechanism.
The civil process itself.
Yes, expanding civil denaturalization without the safeguards of criminal due process leaves naturalized Americans permanently vulnerable to administrative dragnets and aggressive DOJ priorities. It fundamentally weakens the constitutional security of their status.
And, well, my perspective remains that maintaining the integrity of the naturalization system requires an avenue to revoke citizenship from those who obtained it through deceit or concealed crimes.
Even through the civil route?
Yes, because the federal courts provide a rigorous, independent check against government overreach. It's not just an administrative decree. It requires a federal judge to review the evidence and confirm that the fraud actually caused the citizenship to be granted.
Well, navigating the complexities of immigration law and constitutional rights requires looking deeply at the mechanisms of these statutes. There is always more to explore in the material, and honestly, understanding the history of cases like Maslanjak and Ephraim is essential to grasping what's truly at stake here.
Absolutely. We encourage our listeners to look into those precedents to form their own conclusions. There's a lot to unpack. So thank you for joining us on The Debate. Please remember to like, subscribe, share, and follow the show.